implemented by each sub-inspector, Andhra Pradesh will earn name and fame as the first state to have eradicated the untouchability through conciliation, peaceful methods and means. We have been trying to enforce with the cooperation of the government and with the cooperation of the police. If this is done, we can have the credit of declaring that Andhra Pradesh is a great example for other states. We are trying. The AP government accepted the recommendation and passed the GO number 105 for the implementation of this point of program. But in our study tours, in the implementation of the GO 105, much interest was not shown by the sub-inspector. Others we have to see. We have to make the sub-inspector to take interest and enforce the act. GO number 12848, celebration of Civil Rights Day.
Your report has been circulated among the participants.
But he asked me to speak about the report and recommendations. What should we
read and just leave the
highlight?
Yes.
One recommendation is already.
Yes. Only the highlight. Perhaps
only the second resolution, a recommendation which is accepted by the government. I believe. Article 38(1) of the Indian Constitution mandates the state, which means the executive, legislative, judiciary, to strive to secure to people justice, social, economic and political. The constitutional philosophy laid down by Article 38 enjoins the government, which means all the employees of the state to strive for social equality and fraternity in all spheres of life. Social equality cannot be achieved so long as social disabilities are being practiced against the Schedule Caste. All employees of the state are therefore bound under Article 38(1) to endeavour to eradicate disability and the consequent disabilities narrated in sections 3, 4, 5, 6 and 7 of PCR Act 1955. Alright, following your therefore, even for this also, there is a mandal administration, mandal level administration. I recommended that mandal administration should take part to celebrate Civil Rights Day on 30th of February month. Civil Rights Day on 30th of February month. If that is done by the mandal administration, then within 5 years, untouchability will be eradicated peacefully, without any conflict. Therefore, two recommendations. Other recommendations are not necessary because there are atrocities, murders, rapes, assaults are rampant on SCs and STs in Andhra Pradesh. Wrongful occupation of the lands of SCs and STs by the neighboring rights and the landlords in Andhra Pradesh. Again, we have to depend upon the police administration, revenue administration. If they give cooperation, they keep it done. The question is, whether they give cooperation or not, that depends upon the government. I am very glad that this is the first conference in which judges also participated. Under the Human Rights Commission. Let us have every year let us review the progress that has been made in each state with reference to the judiciary. Of course, I don't like to say anything about the judiciary because I am part and parcel of it. I was also part and parcel of the judiciary. I won't say anything. But in other IPC cases also it is the case, 98% are end in acquittal. Acquittals is not the criteria. Acquittals is not the criteria to say whether it is a false case or a true case. If you say that is a false case, if it is a false case or not, on the basis of the acquittals, then the Indian Penal Code, so many cases are filed. How many end in convictions? How many end in acquittals? 80% of the cases end in acquittals at the magistrate level itself. Then appeals, 20%. Appeals to the High Court, 20% finish. Nothing is the criterion we can act. Therefore, cases will be filed. Some cases will end in acquittal, some cases will file convictions. Therefore, on the basis of that, we cannot judge whether it is a false case or true case. Therefore, some friends, our friend says, he gave 482, all those things are there. In murder case, witnesses turn hostile, suppose. Why witnesses turn hostile? There is no provision for the compromise. There is no provision for the compromise for such offences. When there is no provision for compromise, then parties themselves enter into compromise. When the matter comes before the court, the witnesses turn hostile. Because there is no provision for compromise, the witnesses turn hostile.
Justice Punaya, point well taken. Point well taken. The judges every day are confronted with these kind of problems.
Over. I have completed.
Please.
I have completed.
Actually, the program stipulated doesn't contain an item, that is release of a book by Justice Ramaswamy. So far as Justice Ramaswamy is concerned, he needs no instructions so far as the judges are concerned. We know his brilliant judgments, the landmark judgments. May I request him to release this book?
Which is one of the human rights monitoring agencies in Andhra Pradesh. It has studied the various aspects from the judgments of about 400 judgments, and they have reviewed 112 judgments, and they have given their critical analysis of those judgments, how the judgments are faulty, etc., and they published them. Happy.
Ramaswamy to speak on the landmark statistics.
Brothers and the dais, my esteemed brethren, sisters and brothers, we are running short of time. I know the limitations. All the brother judges who have come from across the country to participate in this colloquium are well versed with the operation of the system of administration of justice, and it is preposterous on my part to speak on it. All of you are aware, Section 40, 41 and 42 of IPC defined offence punishable under the IPC, and 42 defines special law. The need for the enactment of Civil Rights Protection Act The Schedule Caste, Schedule Tribes Prevention of Atrocities Act 1989 are the result of the historic declaration under Article 17 of the Constitution, which abolished untouchability. Its practice in any form was declared to be an offence, forbidden, and any disability arisen thereunder and practiced impunishable by law made by Parliament under Article 35 of the Constitution. And 1955, the Untouchability Offences Act has been made. Pursuant to Elia Perumal Parliamentary Committee report, in 1976, Civil Rights Protection Act, which was named, was enacted with necessary amendments. Still, the atrocities on Dalits have been continued. Therefore, in 1989, the Prevention of Atrocities Act has been enacted, and in 1995, the rules have been made. It is fitness of things. These two laws are special laws. And all of us are aware of the offences of murder, rape, arson, theft, grievous theft, etc., etc., covered by the provisions of the IPC. But because of the social background under which the offences on Dalits and Adivasis are committed, one of my brothers has said that the word Dalit has not been defined and therefore it needs a definition. I respectfully submit that 1935 Government of India Act defined Schedule Caste and Schedule Tribes, and it was defined in clause 24 and 25 of the Article 360 of the Constitution, defining Schedule Caste and Schedule Tribes, and given power to the President of India to notify under clause 1 of Article 341 and 342 of the Schedule Caste and Schedule Tribes, in consultation with the Governor of the state, in other words, the executive government. And 1950, the Schedule Caste and Schedule Tribes have been notified by the President by public notification. Under clauses 241 and 242, subclauses 2, gives exclusive power to the Parliament either to exclude it or include in the list prepared by the President. Therefore, there is specific definition of the Schedule Caste and Schedule Tribes under the Constitution, and the Dalit is a word of oppressed people, and that was introduced in the constitutional law by Justice Krishna Iyer in his judgments. Therefore, it's a part of the constitutional law that Dalit is a word meaning Schedule Caste. And in Tapa's case, the Constitution bench judgment has said that Schedule Caste is not a caste, it is a conglomeration of the group of people who are suppressed and for whom the benefit of the constitutional entitlement under the Constitution defined under the Article 341 and 342 are the identified groups of the people. Therefore, when atrocities are being perpetrated on these social groups, it is the special law that requires to tackle with them. In my speech, because of running of time, I will confine myself only 3 aspects of the matter. It is already raised by Brother Judges. One is anticipatory bail under Section 18 of the POA Act. The constitutionality of the anticipatory bail, the exclusion of the anticipatory bail, was already upheld in the Kartar Singh's case by a constitutional bench judgment, and it was followed in Ashok's case in 1995, 2 SCC 221 by a two-bench judgment of the Supreme Court. Justice Sudhakar Manohar has upheld the constitutionality of Section 18 of the Act and prevention of the anticipatory bail was made a constitutional law. Therefore, we need not go into that aspect of the matter that the accused charged under the special laws are denied of the offence of the benefit of anticipatory bail provided under the normal criminal procedure code, because it is a special law. The reason is obvious. Offences are committed on the list, not on any specific motive, like the one required to be established under the IPC Act. Now, so students have rightly said that the offences are committed not on account of any particular aspect, because of the caste-based discrimination and because of the assertion of the rights by some people belonging to these groups, and which have become a privilege to those non-Dalits, non-Adivasis. It is one of mindset, it is one of attitude, and it is one of the approach by the people towards the social groups which are suppressed and oppressed due to the practice of untouchability. Untouchability has not been defined in the Constitution because of historical reasons. It is being practiced throughout the country in different forms. Therefore, specific definition, it is not possible defining untouchability. Similarly, atrocity has not been defined under the POI Act. It only enumerates, it is an inclusive definition, enumerating various aspects, including those already covered by the IPC offences. Therefore, what is more important is mens rea is an essential ingredient of law, as are the offences committed under the POI Act and Civil Rights Protection Act. In Apabal the case, 1993, Supreme Court, AR 1993, Supreme Court 2143, the Supreme Court dealt with the genesis of untouchability, how it has emerged, how the social problem should be focused by the court. It is well settled law that in respect of the social offences like Food and Nutrition Act, mens rea is not an essential ingredient, though mens rea is an essential ingredient for offences under the IPC. Therefore, in Apabal case, the Supreme Court held that mens rea is not an essential ingredient in consideration of the claims and consideration of the evidence and conviction of an accused for the offence under the POI Act or Civil Rights Protection Act. The simple fact in that case was that the borewell was dug for drawing the water by the Dalits, but it is being used by the non-Dalits. And when Dalits went there to draw the water, they were prevented to draw the water. It was a prohibition of entitlement of the civil right to draw the water. Then that factum was proved. That was accepted by the trial court, and it was accepted by the appellate court, and conviction was confirmed. But in revision, the learned judge of the High Court went to the oral evidence, and oral evidence, because there is a discrepancy in the nature of the prevention, the learned judge acquitted them. The matter came up before the Supreme Court, and after 50 years of the working of the Constitution, and the Supreme Court held, by holding that mens rea is not an essential ingredient, since the factum of prevention of the drawing the water was established as a fact, the offence is proved, and conviction was confirmed, and the sentence imposed by the trial court was confirmed. As regards the third area, namely taking cognizance of the offence, is concerned. I was a member of the Dr. Ambedkar's International Celebration Committee, and I was also chairman of the Legislation Committee. I had recommended, seeing this problem, to amend the law and introduce a specific provision that the special judge can directly take cognizance of the offence without reference of the committal by the trial court. I had also recommended that There will be delay in recording the first information report due to diverse reasons, and that therefore delay should never be considered as a ground for acquittal. It is a common fact for the knowledge that the SHO has to record the first information report, and many Dalits are illiterate, and when offences are reported to them, normally they do not write what actually spoken of by the victims. As a result, there would be discrepancy in the statement given along with the FIR and also in recording 161 statement. Therefore, I had suggested that the evidence given before the court shall be taken to be the evidence despite Section 154 of the Evidence Act of the contradictions, so that acquittal cannot end on account of the discrepancy between the 161 statement and the brought out in the evidence and the substantive evidence given by the witnesses in the record in the trial. Unfortunately, till date, they have not been amended. Unfortunately, the division bench of the Andhra Pradesh High Court, which has held that the cognizance cannot directly be taken by the Sessions Court unless the matter has come through the capital order by the Judicial Magistrate First Class. That was approved by the Supreme Court in Ashok case 2002 SCC case, I think 551 or I think or so. Therefore, now it is a law under 141. It is for the Parliament to amend the law, and we can't proceed further in that matter. The third area which I have come across is passing the proceedings by our honorable judges under 482 of the Criminal Procedure Code, because prima facie evidence has not been established and all the ingredients have not been at the stage of investigation. I have come across several cases ending in that. My respectful submission in this behalf is that some judges even quashed the charges because at the stage of filing for anticipatory bail, there is no sufficient evidence brought by the prosecution. First thing, anticipatory bail cannot be granted, which is the law now. And second thing, while considering even for grant of bail, my respectful submission is, it is premature to go into the prima facie case at that stage. What all that requires to be done is, call the report of the investigating officer's case diary and find out from the case diary whether it is being proceeded on the correct lines or not. And if it, even on the face of it, if it is not made out, then it is open to the court to pass it. As I have said, it postulates of two things. One, offences fairly falling under the IPC and offences falling under the special law. If the part of the evidence that could be called under the IPC, then it need not be passed. The state of it can be there. If it does not fall within the squarely under the definition of the offences under the special law, then it is to be considered. In our experience as a member of the National Human Rights Commission, we have seen that many a case they normally omit to charge under the special laws. The reasons are twofold. One, either to help the accused from the stringent law, or to deny them the compensation to be given under the 1995 rules. Either of the things may be possible. But National Human Rights Commission in several cases have directed the investigating officers to register the crimes under the special law, and even the latest report given by Justice Anand, the chairman of the National Human Rights Commission, to the Government of India is also in that line. Therefore, my esteemed brethren, kindly consider when you are considering at the stage of grant of bail You need not meticulously go into these aspects, except when the trial took place and the accused are convicted or acquitted, whether the offence either squarely falls under the special law or falls under the IPC offences. In my respectful submission, as I have mentioned earlier, for committing the offences as against the Dalits and Adivasi, it is one of attitude, it is one of mindset. Therefore, my respectful submission for your kind consideration is kindly approach the problem from the psychological perspective of the accused, not necessarily from the perspective of mens rea alone. That is my respectful submission for your kind consideration. If you consider from that background, what the court requires to consider is the essential ingredients constituting the offence under the special law have been made out or not. If it is not made out, rightly, they should be acquitted. I have come across most atrocious case with great respect where the Chief Justice of the Orissa High Court, a division bench judgment, acquitting the accused. Recently I read that judgment, copies of the judgments have been given to me by Sakshi. The facts are simple. House and Herrick were burnt by the accused, and the owner of the house is a direct witness, and the Herrick belongs to his brother. He stays away from that place. On hearing the commotion raised by the PW1, all others came there. Of course, there is an embellishment in that case that extrajudicial confession was introduced that was disbelieved by the trial court itself. But believing the evidence of PW1 and neighbor PW4, the trial court convicted them for the arson and imposed the punishment prescribed under the special law. What the learned Chief Justice has done in that case was, the evidence with the disbelieved rightly was also not considered by the High Court, unless the public prosecutor processor is considered. The evidence of PW4 was disbelieved. The suggestion given to PW4 in that evidence that the accused was inimically disposed towards PW1, therefore he was falsely implicated, that was the suggestion. But that suggestion was not even given to PW1, the victim. Relying upon this suggestion, disbelieved the evidence of PW1 and acquitted the accused. That is most atrocious judgment given by no other than the Chief Justice of the High Court. With great respect, I can't appreciate that approach at all. Therefore, my respectful submission is, kindly consider the evidence on its face value, appropriate psychological approach, and give the utmost consideration with liberal attitude. Proof beyond doubt is one of the principles criminal law system has evolved and it being followed. Of course, the Malimat Committee has recommended and is now subject matter of law to be made by the Parliament and it is being introduced. And till then we need not go into it. But proof beyond reasonable doubt should not be a mind of a vacillating that of a doubting Thomas. It should be one of pragmatic approach, not pedantic approach, as was done by the Chief Justice of the Orissa High Court. Therefore, my respectful submission for your kind consideration is, kindly consider the evidence of the witnesses that have come before you, who are the most illiterate people and who are not able to speak to you in an eloquent language which others would speak of, but collect the facts, and if there is any accepted evidence, kindly consider. There was suggestion that false cases are being booked, as one of our other judges from Madhya Pradesh High Court has said, and that therefore there is a need for special law. Let us go for the general law. It is not for us to decide that a special law should be made or general law should be retained. It is for the Parliament to do that. So long as the law is there, it is our duty to administer the law within our parameters. And false cases, maybe some cases, if it is a false case on its face, sweet, but many a case, as was suggested earlier, that it is the investigating officer that was responsible for these things. It is not for the witnesses doing that. Another thing is investigation by the Deputy Superintendent of Police. The concept of investigation by a higher officer was introduced only with a view to see that the experienced officer would investigate into this matter and expeditiously deal with it with a specialized knowledge. Many cases are being acquitted on the ground that DSP under Rule 7 of the rules was required to investigate and he has not done it, and that therefore investigation should be, the acquittal should be made. My respectful submission in this is twofold. One, it is settled law that irregularity in the investigation per se is not illegal unless grave prejudice is done to the accused. And courts have held that either charge sheet or acquittal should not be made on that ground. I came across two judgments, one of the Siddiqui of Madras High Court, where the learned judge has directed the Deputy Superintendent of Police to look into the investigation done by the assistant sub-inspector or sub-inspector or inspector, and if it is in correct lines, then file the charge sheet. That is the correct approach adopted by the learned judge. I have come across one judgment of the Andhra Pradesh High Court, Justice Hanumantu, where the learned judge has said that merely because the investigation was not done by the DYSP, it should not be end in acquittal unless grave prejudice is shown by the accused in the conducting of the investigation. Of course, it can be said in two ways. Where the DYSP was entrusted by rule to investigate into the matter, it is per se jurisdictional matter, therefore it is not within the power of the inspector or sub-inspector to investigate into the matter. But being an investigation done by an officer, whether that investigation per se is void or not. There was one judgment of the Supreme Court which I have from Bihar. I have dealt with that illegality in the investigations is not a ground to pass the charge sheet. Therefore, my respectful submission to my fraternity is that kindly consider this aspect also, that unless grave prejudice is shown in causing to the accused, it may not be a ground to acquit the accused in this matter as well. To remedy that, I have suggested in my paper, I think it was circulated, that the periodical training programs should be organized by the government for the investigative officers, and exclusive jurisdiction should be given to the DYSPs of the concerned area to investigate into the offences, and they should be monitored regularly by the senior superintendent of police, and so that grave injustice could not be done in this matter. Another area also is of the special public prosecutors, where that is an administrative matter. We need not go in here. I dealt with in the paper so that somebody can look into that matter as well. I think I have taken enough time. Thank you all.
Thank you, Mr. Ramaswamy. We will have the Justice's intervention after Mr. Kristen speaks. Mr. Kristen was the Secretary to the Government of India. He has worked for the upliftment of Schedule Caste and Schedule Tribe and was in various capacities as the member and secretary of the National Commission for Backward Classes, Chairman Planning Commission, and various other groups. May we have the privilege of hearing Mr. Please.
Honorable Justices on the dais and participating in the colloquium, other eminent scholars and activists on the dais and in the audience. It is a great privilege to be able to exchange experience with some of the leaders of the judiciary of the whole country, share my experience and also benefit by their own experience and appreciation of the situation and enrich my own future approach to the problem. My experience with the problems pertaining to the Schedule Caste, Schedule and backward classes is more or less as old as India's independence. Before I entered the IAS in 1956, in a learning youngsters capacity, subsequently in the service, in my different capacities, either directly or indirectly. And after retirement, I continue in this field because I feel that this is part of the core of the disease that India is suffering from, on account of which it is not able to achieve its full potential, it is not able to compete with its natural competitor, China, and the capitalist is growing. I am worried that we will fall back unless 75% of the people, SCs and SCs 25% of the people, but the majority of the laborers of India, unless they feel that justice reaches them, as Justice Lahoti mentioned in India, understood India empowered, India explained India empowered, unless they experience our political democracy or the whole system will be jeopardized. As Justice Anand also has referred to in his recent lectures, that the alternative is now between those who believe in taking the law in their own hands, whom we call Naxalites. Justice Punnaya, in his personal interaction with me, told me that in districts where Naxalite presence is strong, there is not untouchability. Districts where Naxalite presence is strong, people are afraid to commit atrocities or occupy Schedule Caste lands. This is not a happy reflection on the system, whether it is executive or the judiciary or the legislature. I think it's a big danger. I am not approving of violence, but we should not create a situation that people feel that all this is false, falsehoods, and power comes only through the justice comes to the barrel of the gun should not be allowed to happen, and we have to find ways in which a problem that exists is resolved. I have gone to the largest number of Schedule Caste bastīs, backward class villages, the tribal tandas villages in the country, in my 50 years of public life, in the service also. So then even now, I've been to Gohana personally, where 55 houses of Dalits were burned, pakka houses, and 95 houses were looted or household goods were destroyed. The motive I shall come to in this time, but it was to attack, to teach a lesson to the Valmiki: you shall not dare to change your occupation. You shall not question your encroach on the Valmiki temple's land. So these are problems. Unfortunate. People are all good, but when it comes to this issue, somehow something else takes charge. Dr. Jekyll goes and Mr. Hyde takes over. I will run to there's so much of material with me, it's so difficult to compress it within 15 minutes or 30 minutes. I have put in here a lot of material which perhaps you may find it useful later. It will be in your collection that you will take from here. Meanwhile, I shall just run through some of the earlier things and then come to the final thing about the deficiencies in that and deficient implementation which are coming in the way of the benefit of these two acts reaching as intended in the Constitution and the laws to the suffrage. My good friend, the late Justice Poti, former Chief Secretary Chief Justice of Gujarat, with whom I share the same hometown. He's 10 years older than me. He was 10 years older, but we shared the relation of comradeship and friendship. He used to say that every judge must know sociology. so that you know the background of why certain things are happening, where they are collectively happening. Individual crimes are different, but where it is happening to a certain community, between two communities, then what is the sociological background? I have brought out a diagrammatic presentation of the caste system as it weighs down on the lowest, with considered scheduled caste or agricultural laborers typically, along with tribals outside the tribal areas equally vulnerable, and then nomadic, semi-nomadic communities and former criminal communities. Please change of name. Just Chinnaparity referred to felicitously in one of his judgment system of gradation and degradation. Dr. Baba Sahib Ambedkar referred to a division of laborers into watered compartments, and the hierarchy in which division of laborers are graded one over the other, and a stratification of occupations. And one of the purposes of the caste system, here is a diagram. I won't go into details of it. Kindly go through it. And the bottom layer is the one on which the maximum weight, maximum pressure. To this day, 80% of the scheduled caste live in the, only 20% in the urban areas, 80% in the rural areas, being as agricultural laborers. For others, 32% urban, here 20% urban, 20% urban. And then above that comes the more backward classes, above that the present backward classes, and above that comes the privileged categories. Doesn't mean every person in those categories are in their occupation, but all those in the field are in that category, broadly speaking. Then I have referred to the functions and effects of working on the caste system, not including whims and fancies. It has been operating as a prison house, keeping people in their place. They should not come out of the appointed place, the appointed service, the appointed economic role. Agricultural laborers shall stay as agricultural laborers, agricultural caste shall stay as labor caste, scavengers shall stay as scavengers. Incident there was also mentioned, that comes later. Then this is achieved by a coercive mechanism, because nobody would like to be laborer always, nobody would like to be scavenger always, nobody would like to be a barber always. So this was achieved by two instrumentalities. One is untouchability over the centuries, which continues to this day. A perfect instrument for its Machiavellian purpose. And then, as its effectiveness wore down on account of modern movements of various types, reformist, nationalist, communist, socialist, and Ambedkarite. So people began to challenge untouchability, rejected its ideology. Then the weapon of atrocities began to be used, initially in stray cases, and in the 60s onwards on a large scale. Then, on account of this, what is the present existential situation this is? What are the important features? I have listed them all out. At present, kindly don't try to go through it just now, because it is detailed and I am leaving the papers with you. But broadly speaking, it includes continued condemnation to agricultural labor servitude, landlessness. It was fostered by even formal law. In Punjab, the Punjab Agricultural Land Alienation Act, which made it impossible for the Chulas and the Chamars to own land, and they were driven out of their land. There was also similar acts in some other places like Tirikadwal. But the system of untouchability was the most effective. Then, poor laborers, whatever little land they have, poor wages, bonded labor, more than 60% of the bond labor are scheduled caste, child labor, marginal migrant labor, condemnation to safai. Funds were given for the rehabilitation, those ones were snatched away and diverted. Crores of tens of crores of rupees, I can give examples of it, and brought it home to everybody. Then, prominent presence in unorganized labor sector. There are quality education and level playing field. Money was provided for quality living field, 250 crores added in 1996. Additions to it, that money was snatched away. The non-access to education relevant to market opportunities, low dividend allocation, high AMR and under 5 AMR, infant mortality. I give those figures. Shrinking of existing opportunities, non-access new opportunities. Endemic continuation of untouchability, bursts of atrocities. Vulnerability, even in the matter of filing FIR, evidence, and great vulnerability. They are the majority of the laborers, but a minority of the population. Similarly, I have given account of the existential situation of the STs. I won't read details of it just now. Then I have given the antecedents of the PCR Act 1955, before and after the Constitution, reference to Dr. Ambedkar's exposition in the Roundtable Conference, then the Mahatma Baba Saheb dialogue in Yeravada, which ended in the Yeravada Pact, which is historical. Unfortunately, the spirit of it was not followed subsequently, except in some respects. Then the enactment of the PCR Act, starting the Constitution, delay of 4.5 years, 5.5 years after the Constitution before the Act was made. That was sense of urgency. Then individuals realized the Act is not adequate. It took again so many years, up to 1972, to introduce a bill, and 4.5 years more to pass the bill as an act which is now the PCR Act. Then similarly, the antithesis of the Prevention of Atrocities Act, its impact positive. There is a feeling of protection in the Schedule Caste. There is a wariness in the process. But when it's not fully reaching, because basic contradictions have not been addressed, basic vulnerabilities have not been addressed, and root causes have not been tackled. And there are certain deficiencies in the Act, deficiencies in implementation, the result of which the benefit is not fully reached. And the problem we want to solve is not getting solved. Then basic contradictions, vulnerabilities are given an account in the next exposition. Majority of labor, minority of population. Then socio-ideology of ICS, because of which, as is Indian caste system, because of which the laborers of other castes don't align with the laborers of the scheduled caste, but prefer to align with their own castemen and the larger landowners of their own caste. This factor again isolates. This is the role of the caste system, which we all deplore. I have seen it on the caste system, every possible way. But the caste system doesn't leave society. I can secede because I am in a particular position. I can throw it away and say that I don't care for this. But then the person in the village is hanged to death in case he marries outside the community. In some parts of the country, not all parts of the country. Then, as I mentioned, two of the vast majority of the scheduled caste, 80% of the rural population, the juxtaposition of an agricultural labor caste, typically scheduled caste, with a caste to which the large landowner, not everyone is a landowner, but the major landowners belong to a particular caste. These are the two castes between there is a contradiction, which is expressing instead of atrocities because of the unequal numbers, unequal strength, the isolation of the caste system. So this is one of the basic contradictions. Then dissonance between economic subservience and ideological rejection of subservience. So like I mentioned, a number of basic contradictions. Then Dalit demands of better wage, land, these are resisted to the land and classes. Dalit resistance to discrimination and equality become an eyesore. Then upward mobility is an eyesore. This happened in a number of places. Chunduru, one of the reasons was scheduled caste getting more educated, they were getting better dressed. I have been to Chunduru on 11th of August. 6th of August was the date of the occurrence. The case is still languishing. The real trial started only in 2004, 1991 and 2004. Similarly, there is a Kumair case which is still languishing. Then even where they have achieved limited mobility without reservation, as in Gohana, that also is an eyesore. Then where they resist incursion Valmiki temple lands, that becomes a cause of resentment. Then civil society either hostile because of their own origins or indifferent because this doesn't matter for them. Then I have analyzed the atrocities by specific causative factors with examples, many of which I have personally visited and inquired into. They are wage-based, bond labor-based, land-related, civic facilities related, where the dead bodies of two women, one in Andhra Pradesh, Nizamabad district, prosperous area, Pachalnagapudi village, and another in Konalam, in Tamil Nadu, North Arga district, who were held up in the pathway, dead body of old women, because of a dispute over the pathway. In the case of Konalam, provided by the government, but the powerful people don't allow this dead body to go unless something else was done for them. Others, they were held up. Then untouchability graduating into atrocities. Then assertion and dignity related, that is happening more and more now. Chunduru, there is no wage dispute, no land dispute, no material dispute. It is only on the question of dignity, assertion, equality, etc. Then, I have also analyzed across the Schedule Caste, which stands for different footing. Then I have brought up the deficiencies in the PO Act. The major defect in the PO Act is pointed out also by the National Commission to review the working of the Constitution, chaired by Justice Venkatacharya, of which Justice Punne was a member. I was closely associated on this Justice Venkatacharya's initiative in preparing the Chapter 10. Justice Ramaswamy was also the chairman of a committee, who was not a member of the committee. So we have all worked together to put all our minds. And Justice Venkatacharya's contribution was one of the greatest, because it was one of the best humanities I have seen. That was also recommended. There ought to be exclusive special courts, so that if a crime takes place, it should be quickly tried. And those ones guilty should be punished immediately, those guilty should be released immediately. And those acquitted should be released immediately. Some of the problems that rightly Justice Butcher were pointing out are on account of the delay in the trial. Acquittals also are, the people are not able to remember, people don't give evidence, charges paper on the browse through. That brings out the effect of delays. And the demoralization among the victims. Please let us also remember Mukhtar Mai's case in Multan, near Sarhind, where there was a gang rape of a girl belonging to a landless Gujar caste by men of an upper caste. Religion is not, no religion is exempted by the caste system in the subcontinent. And Musharraf said, when accosted about this, it is easy for any woman to allege rape and then get money and get a visa to Canada. Later on, he apologized for that. So, now, this problem of people not being able to remember, people being coerced, people being tempted, allured. Recently, the case of the lady from Gujarat, which Supreme Court has taken note of, and where it has completely been brought out how a victim can be bought over or terrorized, allured, and go against one's own evidence. All these things happen in the case of these, which has to be kept in mind in the spirit in which Justice Poti spoke, as a sociological backdrop to what is happening in society in judging, for example, evidentiary value. Then, this is one major deficiency. I also know why it took place. I recommend, even at that time, I was part of Dr. Shankaranand's team, who was a law minister. My own ministry didn't want me to participate. I said that there should be exclusive special courts. Instead, the mischievous words specify a court of session in the district. You call existing court special court, what purpose does it make? So the same delay, the same problem, the same overload has been taking place. This is a major deficiency recommended to be corrected by the National Constitutional Review Commission and not attended to. This is one of the places where the collective weight of the higher judiciary would help in giving directions, because one thing that government is respectful to still is a direction from the bench of the High Court of the Supreme Court. Then, I have referred to the possible help from the judiciary against this. Then I have given a statistical analysis of the PO Act. Kindly, just take a glance. This is an important part of it, that I have taken the reports, annual reports of the last 5 years. Last is 2003. The cases in trial completed out of those in the court in the course of the year ranges from generally from 10 to 15%. Only in 1 year, 21%. Convictions range from 11 to 13%. Acquittals 88 to 89%. Out of the cases in the court pending, only 2% or 1% end in conviction. Out of the cases pending in the court at the beginning of the year, only 12 to 20% are disposed of, and these are acquitted. 99%. Then I also mentioned the effect of this on the people. They don't know statistics, but they know Chunduru trial did not take place till 2004. It went on peripheral issues. Kumeya trial was shuffling between commission, committee, and then normal court, and then special court, and still the trial has not taken off. So all in all, though the Act gives some sense of security, the purpose is not reached, and the people feel that all these are only eyewash. It's not intended to really help us. Therefore, think of the next side. Then there are serious problems which are not addressed. Probably the High Court can give a direction to the government or appoint independent person to. How can I explain that in 2001 there were 9,764 cases of atrocities against SCs? There are very few SCs in Uttar Pradesh. In 2001, dropped down suddenly 5,841 in 2002, and in 2003, 1,700. Either some signal has gone, don't register, or is it Mayavati? In that case, we are giving a signal. That is the only way out, either Mayavati or Naxalite. Then I also mentioned the various ways in which the judiciary could possibly help in giving a positive direction to the executive to see that the implementation problems are addressed. Then I have analyzed the deficiency in the PCR Act. Main deficiency is mobile courts are not there against. Then analyze the cases. In the whole of 2003, only 13 convictions were there in the whole of the country. Out of 7 in Andhra Pradesh, 3 in Maharashtra. I think some lopsided in this case. In many states, no conviction at all. In Tamil Nadu, out of 2,000 odd cases which were disposed of, 2017 cases, all were acquittals. I will give an example. Then the fall in the number of registrations in the case of PCR Act also often coinciding with the elections. Then I also refer to possible help. More than what I can say, whatever I have is only suggestions. But those who have been spending their whole lifetime in the dispensation of justice, in the spirit of various earlier luminaries, and also in the spirit of what Justice Lahoti has said, recently, they probably are the best qualified to see how, when crimes are taking place, untouchability is rampant. They are not being reflected in the cases registered. They are not getting convicted. Crime is taking place, punishment is not taking place. That mismatch, crime without punishment, is a very dangerous thing happening in the society. How to resolve this is a serious dilemma on which depends the progress of the country as a whole, not only the termination of the sufferings of the SC and ST, and also the continuance of the democratic polity of the country, including the judiciary. Dr. Ambedkar referred to that. Justice Lahoti also referred to that recently, that political freedom is not enough. Unless socio-economic freedom also is there, equality is there, then the system is jeopardized. These are points which I have put across for possible thinking. I have been in this field out of my choice because I consider this a central area, not a peripheral area. It affects, in the case of Islam, 1 out of every 4, and the vast majority of the laborers of the country. We cannot pull forward the country unless these people feel, yes, there is substantive justice in our case. Subject to aberrations that people can tolerate, but substantive justice is taking place in most of the cases. And untouchability is disappearing. It can disappear. If with Naxalite control of a district, untouchability can disappear. As Mr. Pune has personally found, people in Sovereignty won't come and give a complaint. And he asked them, why are you so cowardly? Why don't you tell me what is happening? They said there is no untouchability here. Annalu means the elder brothers. The untouchables, these Naxalites are looking after. There is no complaint for us here. So, out of the concern as a patriotic Indian, which has been the guiding light of my life before service, during service, after service, apart from the humanistic issue of justice for the SC and ST and termination of the long-standing sufferings, I appeal to the learned judges, past and present, to help in finding out how can we ensure that this type of crimes, which are intended to perpetuate a self-defeating, an anti-constitutional, anti-patriotic type of crimes, how to prevent them from going unpunished and how to relieve these people, the SC and ST, who are like us in color and other things. It's not like Suresh going to America and they are all white and he's brown. All are brown. And how these people who are our own, some of them have become Muslims also, or become Christians also, but these remain Dalits. All the children in Karamchand were Christians. But they were not because they were Christians, because they were Magidas. Chunduru, both communities were there. Hindus and Christians were there. Killed, not because they were Hindu or Christian, but because of the caste that they belong to, both Bhara and Madila. So in this situation, I feel I am nonplussed, I am agonized, I am looking for light, doing whatever little things I can do. I went to Bhara, it gave some relief to people that somebody came who is not born among them, but who could attend to, and some of the issues I could solve with the civil collector. I wrote to the government about some other matters, to the top level, all know me personally, but results are not there. Judiciary can't be an effective instrument. As again, Justice Laudi as a judiciary has got the best tools, and judiciary is central to justice, and justice is central to the polity and the constitution. Thank you very much.
Justice Ramaswamy has expressed his desire to respond to Justice Kulshresth's query. I think Justice Kulshresth's question has irritated many of us, and we would like to have his comments on that. I must clarify Justice Kulshresth's position. Actually, it's not a view which he has expressed. It's not that he is having a view and expressed that view. As a judge, one is confronted with such a situation and he wants the reaction of the people on that. It's not that it's a view that every witness is a hostile or every witness is not a hostile. Many a times judges do face that situation and he wants the assistance and the guidance of the House on that.
I will clarify that it is not that this House is considering the virus of Section 18. What I suggested was that there should be certain checks and balances. Now, if you provide for a stringent provision, where even a section like 315, which provides for